Good afternoon, and thank you for joining our panel discussion today, Banning LGBT Discrimination in the Workplace, Implications of the Supreme Court's Landmark Ruling in Bostock versus Clayton County. My name is Elizabeth Minifar, and I'm an employment law associate at Paul Hastings, LLP, here in Los Angeles. I will be moderating this panel today with my colleague, Ryan Derry, who I will let introduce himself.
Good afternoon. I'm Ryan Derry, and I'm a partner with the Employment Law Department here in San Francisco with Paul Hastings. And we are incredibly excited to have such a stellar panel of experts in the area of LGBTQ rights and law to discuss the Supreme Court's recent groundbreaking ruling, its impact to a variety of areas of the law, and what this decision may hold for the future. With that, we'd like to take a moment to introduce our esteemed panel.
Great. So first on the panel today, we have Brad Sears. He is the Associate Dean for Public Interest Programs and the David Sanders Distinguished Scholar of Law and Policy at UCLA School of Law. Brad was also the founding director and executive director of the Williams Institute, which is the leading research center on sexual orientation and gender identity law and public policy. Thanks so much for joining us today, Brad.
Great to be here. Thank you.
Next up, we have Adam Romero. Adam is the Deputy Director of Executive Programs at the California Department of Fair Employment and Housing, or the DFEH. Adam is an expert in anti-discrimination law and multidisciplinary research, and he leads the DFEH's Executive Programs Division. Thanks for joining us today, Adam. Next up, we have Shannon Minter. Shannon is a longtime transgender activist and the legal director of the National Center for Lesbian Rights, one of the nation's leading advocacy organizations for lesbian, gay, bisexual, and transgender people. Thank you so much for joining us, Shannon.
Oh, thank you, Elizabeth. I'm really happy to be on here with such great folks.
Thank you. Next up, we have Bambi Salcedo. Bambi is the president and CEO of the Trans Latino Coalition, a national organization that focuses on addressing the issues of transgender Latinos in the U.S. Thank you for joining us, Bambi.
Thank you so much for the opportunity.
All right, and last but certainly not least, David Brown. David is the legal director of the Transgender Legal Defense and Education Fund, whose mission it is to end discrimination and achieve equality for transgender people, particularly those in our most vulnerable communities. Thank you for joining us today, David.
Thanks for having me, Elizabeth. It's a great pleasure to be with this group.
With that, I think Ryan will be providing us an agenda for our discussion today.
Certainly. So on the agenda today, we plan to start with the background. There's a trilogy really of 3 cases that we want to talk about. We'll generally refer to as the Bostock case and the facts leading up to those cases, as well as the court's ruling. Then we'll turn and look to the current state of discrimination against LGBTQ individuals. We'll talk about the impact of the Bostock ruling on employment law. We'll look specifically at the impact of the court's ruling on transgender rights. And then we'll talk about what effects we expect to see other areas of law beyond employment, including religious rights, Title IX, and the Affordable Care Act. Finally, to the extent we have time, we'll look to the future and think about what we expect to see coming down the pipe from the Supreme Court, especially in the wake of Justice Ginsburg's recent passing and shifting dynamics on the bench.
Great. And with that, Brad and I will first give a bit of a factual background of the Bostock case and, cases, the 3 related cases, and the Supreme Court's recent ruling. So turning first to the facts of the 3 cases that were before the Supreme Court, as I mentioned, the decision combines 3 separate cases involving similar claims in which an employee was fired for being gay or transgender. So specifically, those 3 plaintiffs are, one, Gerald Bostock, who was fired from his county government job in Georgia for conduct allegedly unbecoming a county employee after he joined a gay softball league. Then Donald Zarda, he was fired from the skydiving company where he worked just days after he had mentioned to a customer that he was gay. And then Amy Stevens, she was fired from her job at a funeral home after transitioning at work. And so each of these employees sued their respective employers. Those claims were all in different jurisdictions, but they each asserted sex discrimination under Title VII of the Civil Rights Act of 1964. And the cases had different results at the local level, but were ultimately appealed and consolidated under the Bostock case before the Supreme Court earlier this summer. Now, before we get into the court's holding, Brad, I understand you have a bit of a personal connection to one of the plaintiffs. Could you please tell us about that?
Yeah, thank you, Liz. And we're going to talk a lot on this panel about law and policy and some research, but I think it's always important to remember the great sacrifice it is to be a plaintiff in one of these cases, and that the stories in these cases are just representative, I think, as Adam is going to show, of tens of thousands of people across the United States. I think what's similar in all three of these cases is that people were discriminated against because they just wanted to show up for their jobs, of who they, just how they were, who they are, and to live their lives. So you had someone who was fired for wearing the clothes consistent with their gender identity, someone who was terminated because they wanted to play in a recreational softball league outside of the workplace, and someone like Donnie Zarda, who was actually trying to help a customer feel more comfortable in a skydive, who was female, by saying that he was gay, and in the close physical contact of a skydive, hoping to ease that situation with her, and for that he got fired. I think in all of their lives, that moment of termination marked a moment that so many LGBTQ people experience over and over again in their lives. I grew up in a town of 90 people called Grain Valley, Missouri, on Rural Route 2, which was the name of our road, which ran into Buckner-Tarsney Road, which is the county line road. And Donnie Zarda actually lived kind of two farms down from where I grew up. We went to the Little Red Schoolhouse, which was the only preschool in the area, and through the same public high school system there. We're a couple of years apart. But, we grew up in the Midwest in the 1970s and 80s. We grew up in a school district where, and in a town where I knew of two real live LGBTQ people. There was the bi girl who got beat up and then had to transfer out of our school district. And there was the rumored to be gay guy who got stabbed behind the gym and had to move out of our school district. And I think Donnie and I are very different people, but we followed a same path of leaving that environment, kind of fleeing to the coast, and living our lives there. Donnie was somebody who really defied kind of the outdated stereotypes about LGBTQ people. He was a tough guy. He liked extreme sports, and that's what he wanted. That was his passion. So he also moved to where those jobs were. And in doing those extreme sports, skydiving was a safe gig. It was a safer gig than many of the other activities that he wanted to pursue. So when he lost that job, he was scared that he'd never get a job doing skydiving or instructing again. So he turned to a job in base jumping. I may not get this right, but the base in base jumping stands for building antenna span, which is like a steel beam high up on a skyrise, or a bridge, a span like a bridge. And I'm blanking out what E stands for, but you get it. Stationary objects not too far away from the ground where you jump off in a parachute, delay for a while, and then open that parachute before you hit the ground. And he died doing a base jump. So it's a dramatic story, but I think it's a story that a lot of LGBTQ people can relate to, where discrimination, stigma shapes so many aspects of our lives. And despite that, people overcome and then are brave enough, like the three plaintiffs in this case, to go through the public attention and scrutiny to bring a case to the Supreme Court.
Absolutely. Thank you, Brad. So before we jump into sort of the impact of these three cases, let's talk briefly just about the court's ruling. So the court determined in a 6-3 opinion authored by Justice Gorsuch that essentially an employer who fires an individual merely for being gay or transgender, LGBTQ, that in and of itself is a violation of Title VII. In reaching this conclusion, the court explained that while Title VII does not explicitly refer to an employee's sexual orientation or gender identity, this sort of discrimination is prohibited by Title VII's reference to discrimination on the basis of sex, which is interpreted to include sexual orientation as well as gender identity. Now, there were three dissenting justices who essentially contended that the result was not intended when Congress passed Title VII decades ago, and that the court had overstepped its bounds by extending these rights to LGBTQ individuals. Now, while the majority acknowledged that few in 1964 would have expected Title VII to apply to discrimination against LGBTQ people, the court did not focus so much on the legislative history of Title VII because, as it ultimately determined, the language of the statute unambiguously prohibits discrimination against LGBTQ individuals. So before we look at the impact of this landmark ruling, let's talk a little bit about the current state of discrimination against LGBTQ people. Adam, I'd like to turn to you first, given your role at the DFEH, which is the California state agency where employees can file claims of discrimination. So can you please tell us a bit about your observations of the prevalence of sexual orientation and gender identity discrimination in employment?
Sure. Hi, thank you, Liz, and hi, everyone. It's great to be here. Actually, before I was appointed to the California Department of Fair Employment and Housing, I was a senior scholar and Brad's colleague at the Williams Institute, and so have a research background. And so I wanted to just share, I think, some of the sort of canonical, most recent research that is helpful in terms of understanding Gerald Bostock, Don Zarda's, and Amy Stevens' cases, because what those cases are part of is a broader context in which LGBT people face widespread discrimination in employment and other settings, even though social acceptance of LGBT people has generally improved over the past few decades. One recent survey from our colleagues at my former colleagues at the Williams Institute of a representative sample of the US population found that LGBT people are significantly more likely to report experiences of employment discrimination as opposed to their heterosexual peers, with 60% reporting being fired from or denied a job, and 48% reporting being denied promotion or receiving a negative evaluation, compared to 40% and 32% respectively of heterosexuals. Similarly, according to a 2017 survey, again, a nationally representative sample, 1 in 5 LGBTQ people reported being personally discriminated against because of their sexual orientation or gender identity when applying for jobs, and 22% said they had experienced such discrimination in pay or promotion. And these surveys are consistent with other forms of research. And one particular body of research that I want to talk about has to do with what's called matched pairs testing, where researchers send out resumes to real live employers who have job postings out there, and the resumes are matched in sort of all respects, qualifications, education background, race, hopefully, as that can be indicated on a resume, except that one of the resumes indicates that the applicant is LGBT. And I think all but one of the recent studies that I've seen of this type have found that the LGBT applicants had to apply to a far greater number of job postings than the non-LGBT person to get the same number of callbacks. And so that's a form of research that allows us to isolate the presence of discrimination against LGBT people very strongly, and confirms what these surveys that I mentioned before find. There's another set of research that I think it's really important for us to consider because it specifically relates to employment and the importance of employment in our society. Really, let me back up and just say there's a popular stereotype that LGBT people are all affluent and have a lot of disposable income because they're not raising children. And certainly that's true of many LGBT people, but the data show that nearly 30% of LGBT adults are raising children, and that's especially common among people of color. In addition, according to research from the Williams Institute, the LGBT population has higher rates of unemployment, uninsurance, food insecurity, and poverty than the non-LGBT population. But importantly, it's important to note that poverty is not evenly distributed in the LGBT population. When you dig into the data, they show that Black, Latinx, and certain other racial minorities are particularly vulnerable, and transgender people of color are even more vulnerable. So let me just end by saying, I think like any community, it's important not to think of LGBT people as monolithic.
Thank you, Ash. Bambi, I'd like to turn to you next. I know you have a wealth of experience working with clients dealing with discrimination on a daily basis. Can you speak to us a little bit about that?
Certainly. Bueno, primero que nada, quiero darle gracias a mi poder superior por darme la oportunidad de estar aquí con ustedes. Y también quiero dar gracias a las personas que nos acompañan hoy en día. I know that it was hard for some of you to understand what I just said, but it is always a customary thing that I do for me to honor my higher power before I speak on any platform, for the opportunity to be here with all of you. But I also want to honor the beautiful and amazing people who are joining us today. I mean, I think there's no secret, right, that trans and gender nonconforming people continue to experience past discrimination simply because of our existence, right? And that is actually one of the primary reasons why we exist as an organization. You know, our organization does both policy or macro level work, if you will, to really influence and influence the change that needs to happen at the structural level. But we also provide direct supportive and life-saving services to our community. And we do that because, as when we started back in 2009, we started obviously with this macro level mentality, and for us to influence those structures that marginalized trans Latinx immigrant women at that time. And as we were trying to organize people across the United States, one of the recurring things that we were seeing is that the very people who were trying to organize were not having access to basic services. And that's why our national board came together in 2015 and decided that in order for us to also address that need, that we needed to move into service provision. And so we exist because of the discrimination that, our community continues to face while trying to access those basic things, right? Like even food. Like, for instance, right now, that we're experiencing this global pandemic, right? We have had cases that have been reported to us by members of our community that when they have tried to access food at food banks, they really, like, it's oftentimes denied that service, and even ask questions as to do you have family, right, to feed? And that's Obviously, those are some of the things that obviously, deter people from seeking those services. But obviously, trying to access healthcare services or even employment, right? Our community continues to have those types of experience, and again, unfortunately, members of our community continue to be discriminated simply because of who we are, and we also are criminalized simply because of who we are. And this is something that is um, that continues to happen to our community, and that's why we as an organization want to make sure that we not just advocate at the macro level, as I mentioned, but also that we empower members of our community, because we know that even if it's food that we can provide to our community, that's a form of empowerment, and that's how we are obviously tackling these issues.
Wonderful. Thank you, Bambi, for sharing that. And so kind of turning from there and setting the background as to the discrimination, certainly that we're aware of that LGBTQ members of our community are facing, we wanted to turn and talk about the Bostock case and what we can expect coming from it, right? We herald it, we hold it up, we're excited by that decision, or it's a decision that was a long time coming, and maybe we're not excited by it because it should have happened decades ago or years ago, but the decision finally did come through and setting forth with respect to at least some minimal protections as to discrimination for our community. So David, I want to turn it to you and kind of talk about the population as we look at the Bostock ruling. Who is impacted by that ruling and who really is left out of that ruling? What do we see of the impact of it?
Thanks, Ryan. So in some ways, it's sort of hard to overstate the impact of the decision. And in other ways, the decision hasn't changed very much. And I'll try to talk about both of those things briefly. So in a nutshell, right, what the decision says is that under federal law, you cannot discriminate against LGBT employees because they are LGBT. And that's a huge decision. It's actually unprecedented for transgender people, with the exception of, I think, a single parenthesis in an opinion by Justice Breyer describing some other case. The word transgender had never appeared in a Supreme Court decision ever in the history of this country. And so the fact that the decision came out positively for transgender people is really almost like an earth-shattering event, at least from a sort of a legal perspective. So what it does is it says LGBT people cannot be fired or subject to adverse employment conditions because of their being LGBT. What the cases actually decided was simply kind of that first thing, right? You can't fire people. That was the issue in front of the court. And so what was kind of left undecided, and I think what we'll have to look at a little bit more closely going forward, is what are all of the other ways in which LGBT people can be subjected to discrimination that were also made illegal by Bostock? And we don't fully know yet, but we're beginning to see court decisions, especially in the area of transgender rights, that are grappling with things like sex-specific things. Access to employee bathrooms or changing rooms, the usage of uniforms and things like that, that I think any advocate, anybody on this panel would tell you, Bostock clearly decides, right? Bostock says any way in which you mistreat a person who is LGBT because they're LGBT, so forcing them to comply with your vision of how they should act or be, because they are, because of your opinion about who they are as their employer, has now become illegal. But I still think we're going to have to do some work to actually defend those rights in court. So there will still be some legal wrangling going forward. On the other side of the coin, it hasn't reached a lot of the things that Bambi was referring to, discrimination law in this country, as I'm sure it will not become be a surprise to anybody, has not fixed discrimination, right? The Civil Rights Act of 1964, as the name suggests, is almost 60 years old, right? And it prohibits discrimination on the basis of sex and race and other categories, and we still have all of those things. And so the fact that now sexual orientation and gender identity have been added to that list, right, won't fix those problems overnight. And I talked to a person shortly after the decision came out, a transgender leader in Chicago, and she said, quoting a friend of hers, like, what does Bostock mean to me? I work at Taco Bell, right? And I think, to me that really spoke to me because, sure, okay, Taco Bell now can't fire LGBTQ people because they're LGBTQ either, and I expect they'll follow the law. But what I think what she was really saying, right, is that like when you are faced with such a lifetime of discrimination, right, when you didn't get to go to college, and so you're working at Taco Bell, right, when you've been denied opportunities your entire life, and so the what's left to you is so narrow. Anti-discrimination law doesn't really address those things, and so especially for LGBTQ people of color, LGBTQ people who faced intersectional discrimination, who've been denied opportunities over a lifetime, or as a community, right? The change in law doesn't address that yet. And if you're a glass half full person, there's still a lot of work to do. But if you're a glass half empty person, Bostock simply doesn't change those situations.
Appreciate that, David. And you had mentioned, right, Bambi, did you want to add something?
Yeah, thank you so much, David, for bringing this up, because I know that the type of discrimination that trans people face, and even further, right, trans people of color, monolingual Spanish speakers, those who are immigrants, employers often practice, if you will, right, what I call the invisible discrimination, right? So it is discrimination that you're not able to prove, but it's something that is always there, right? And what is like so prevalent in our community is, specifically when trans people, for instance, have not had the opportunity to have their name legally changed, and they are, they present a particular way, and then when it's time to be hired and present their legal documentation, right, then they're not hired after all, right? And so there's no way to prove that discrimination, which is, again, the invisible discrimination, right? And that's just one example of the particular issues that trans people go through while trying to access employment.
Certainly. And I guess kind of the one point that David had raised, right, is that now we have sexual orientation and gender identity or gender expression status within Title VII, but there's a long litany of protected characteristics within Title VII. So Brad, just kind of wanted to bring you into this discussion and thoughts about what Bostock means in terms of intersectionality or multiple discrimination and what we've seen along those lines.
Yeah, sure. And I think it relates to so much of what we've been talking about. And I guess thinking about intersectionality in this case, you can think about it in several ways. And first, as David was mentioning, this is a victory for the LGBT community built off the Civil Rights Act of 1964. This is a statute that a lot of people, including many Black Americans and the Black Civil Rights Movement, fought for, that is now being expanded to provide protections for our community. And like so many areas, we owe a debt that they have paved the way to provide protections for us. I think, as David and Adam have mentioned, who do people discriminate against? And I think Bambi was saying this too. They discriminate against people they know where they can get away with it. And so as you strip away every layer of privilege from a person, they're more and more likely to experience discrimination. I did a study once with people with HIV and healthcare workers who would discriminate against them. And it turned out there was a certain level of discrimination if you spoke Spanish. It was a higher level of discrimination if you spoke Spanish and were on public benefits. There was an even higher level of discrimination. And so people can assess, employers assess people's power in society, and they discriminate where they can. And I think as Adam put out, as Adam was discussing, whether it's income or poverty or housing stability or food security, in all of these areas, people of color, people who are not citizens in the LGBT community have higher rates of vulnerability in almost any measure that you can find. I think the good news about Bostock is that it actually is opening up a little bit more of the possibilities for going after intersectional or multiple discrimination under Title VII. And so there was actually just a few weeks after a 10th Circuit decision that applied Bostock to a case brought by women who were older. And if you want to talk about a group that's also kind of discriminated against and invisible in our society, it's older women who were also casino workers. And so they were being fired from casinos while older men were not. And the 10th Circuit had let similar claims go forward, but really used Bostock to kind of lower the bar for these types of claims, really because of two parts of Bostock. First, Gorsuch, in kind of deciding his opinion, was using all of these examples to show why sexual orientation and gender identity discrimination, although mainly sexual orientation discrimination is the focus of the video, was violated Title VII. And so he used this example about women who are Yankees fans. And he said, well, this is still discrimination if you don't discriminate against men who are Yankees fans, even though you're not discriminating against all women, just women plus this other factor. And so the 10th Circuit said, that means we can use sex and another factor like sex and age. So it can be another protected category within Title VII, or another federal statute, or even something that's not protected by federal statute. This is really important, and it's really important for LGBTQ people. And if you read the facts of these cases, particularly harassment cases, the people who are being abusive don't just pick one lane about their abuse. Like it's if it's misogynist, it's homophobic, it's transphobic, it's racist. They're not watching their terms, and it's not helpful for courts to parse things apart and only consider one category at a time. So that's very important. The other thing that kind of opened up Title VII a bit in this and other areas was focused on discrimination against the individual and not groups. So the 10th Circuit was very clear. Even if it was discrimination because this particular employee was both a woman and older, and there were other older women who weren't discriminated against, if there was evidence of that was the basis for the decision for that particular employee, that was still a claim. So this is important for LGBTQ people. It's important for anyone facing discrimination that might have a claim under these acts. It's also important, I think another thing we can do to help pay back the debt to the Civil Rights Act is when we amend it through something like the Equality Act, no longer leave this up to court interpretation, but to put in the language that after these long list of categories, intersectional and multiple discrimination is also prohibited. Thanks.
I appreciate that. And I guess the one thing kind of wanted to turn to and talk about now is we think about Title VII, right? Title VII is the federal law. And so you have certain state laws and local ordinances that dealt with and have protections and anti-discrimination provisions related to gender identity, sexual orientation. So Adam, turning to you, kind of as we think about Bostock and adding this at the federal level, where do we expect there to be greatest changes for employers, employees, and how do we see this playing out?
Well, legally speaking, it's kind of a complicated question because we had a complicated set of laws before Bostock too. If I could try to break it down a little bit simply and just look at state level protection, so state level statutes that prohibit explicitly sexual orientation and gender identity, more than a majority of the states do not have protections against sexual orientation and gender identity in employment and other settings in their state statutes, which means, of course, a minority of states do have those statutory protections. According to the Williams Institute, there's about more than 8 million LGBT workers age 16 and older across the United States, and more than half of them live in states without the state protections. Now, complicating this is, in a good way, is President Obama issued an executive order that prohibits federal contractors, so any company that contracts with the federal government, from discriminating on the basis of sexual orientation and gender identity. So if you live in a state like Georgia or South Carolina that doesn't have state level protections, you may have protections under this federal executive order. So what does all this mean for employers in terms of what's going to change? I'm describing that legal background to say for employers in states without state level protections, this does change quite a bit, though there may have been some Court of Appeals decisions that already covered, that were in line with the Bostock decision. For employers in states that have state level protections already, I don't think a lot has changed. So in California, for example, where discrimination on the basis of sexual orientation, gender identity, and gender expression have long been the law, employers were already under obligations not to discriminate in employment. And all Bostock did was clarify federal rights. So the biggest change really is for employers in states that do not have statutory protections and are not federal contractors. It's complicated, but I just want to, I think, echo a very important point that David made about what Bostock did a lot, but it didn't do everything.
Thank you, Adam.
Can I add one more thing to what Adam just laid out?
Please.
Which is, obviously Adam is right. In many states, the kind of thing that the plaintiffs in the Bostock cases experienced was already illegal under their state's law. One thing that the federal Title VII doesn't do is it doesn't apply to employers that have fewer than 15 employees. Although most Americans work for larger employers, actually most employers are small employers that aren't covered by Title VII. Fortunately, many state laws do go lower. And so in those states in particular, there still is some play in the joints there. We would then, as advocates, need to work on ensuring that for states that don't explicitly include gender identity and sexual orientation in their anti-sex discrimination statutes, that they understand the logic of the Bostock decision and begin to apply it to their state's law for those smaller employers as well.
I'll just say one more thing. I'm glad David brought size of employer up, because California, our Fair Employment and Housing Act applies to employers with 5 or more employees in terms of discrimination, and our harassment provisions apply to any employer regardless of size.
That's an important point. Yes, thank you. Shannon, I'd like to go to you next as we kind of shift our focus to a few issues specific to the transgender community, as we saw highlighted in the Amy Stevens case. So Shannon, if we're thinking about Justice Alito's dissent and the couple issues that are mentioned that remain unresolved, for example, the use of pronouns, bathrooms, lockers, trans people in the military, what are your thoughts about what's actually left unanswered and open in the wake of Bostock?
As people have been noting, look, this is a completely transformative decision. And I do want to give a shout out. I think it's so important to remember the advocates and the plaintiffs who laid a groundwork for the incredible victory in Bostock, and especially want to acknowledge Dee Farmer, who was the first openly transgender person to ever appear in a Supreme Court case back in 1994. Dee was an incarcerated woman. Dee's a Black transgender woman who established the precedent for the whole country that prison officials are liable for failing to protect a transgender woman who's incarcerated against sexual violence. So I really want to I think it's important that we acknowledge that. And actually, a lot of the plaintiffs that established all the precedent that the Supreme Court relied on, at least implicitly, when they decided Bostock, were transgender women of color. And I don't think that's a coincidence, because they experienced so much discrimination. Anyway, yeah, so look, Bostock, the issue in Bostock was whether you can fire someone just for being transgender. Amy Stevens, that was the only reason she got fired. She was a great employee, doing a great job. She told her employee that she was a transgender woman and would be undergoing a gender transition, would be working consistent with who she was, woman. fired, and the court's like, no, that's sex discrimination. You can't do that. So of course, like every case isn't going to address like every possible issue relating to anything that could come up with respect to a transgender employee. And there already are other cases in the lower courts, and sure, maybe eventually there'll be cases that get all the way up to the Supreme Court about whether an employer has to allow transgender woman to use a woman's restroom and to just be treated as a woman in all respects in terms of how she's addressed, the dress codes, and that type of thing, and vice versa, of course, for a transgender man. But that may not even be anything the court ever has to decide, because there may very well be unanimity on those issues in the lower federal courts. So there may not ever be a conflict. I mean, that's what we're seeing so far, is that when that issue is presented to courts, they're holding that, yes, discrimination against a transgender person certainly includes excluding, they're like failing to just respect their identity in the most basic sense. So excluding them from an appropriate restroom or refusing to use the right pronouns. Yes, courts are recognizing, well, sure, that's discrimination. And then if you look at the analysis in Bostock, if it applies, it would just apply absolutely in a very clear, straightforward way to a case like that. I mean, the court held when you treat a woman differently because she's transgender, yeah, that's sex discrimination. So treating a transgender woman differently, for example, in access to restrooms or something, would be, under the logic in holding of Bostock, would certainly be also sex discrimination. And we're seeing that, like we already have, even since Bostock was decided, there have been two really important decisions by two different federal courts of appeal. They're about students. They're about transgender students. They're about Title IX, which prohibits sex discrimination in education. And both the 11th Circuit and the 4th Circuit had no trouble applying Bostock to conclude that schools absolutely have to let a transgender kid use the restroom that corresponds to their gender identity, just like they would with any other student. So the short answer is, while Bostock didn't address everything, its analysis would apply to just about any situation you could think of, and including any governmental discrimination. A plaintiff could bring a constitutional equal protection claim, and that would apply, for example, to the transgender military ban. So it certainly put us on a really much stronger footing in terms of challenging the transgender military ban. I mean, we're already on strong footing. All of the lower courts that considered it already said it was impermissible sex discrimination. But after Bostock, I think that is just kind of unmistakably clear. So there are outstanding questions, but I think they're going to be resolved in a very positive way.
Yeah, and building off of that, Bambi, I know, Bambi, you've worked on a sort of broader policy agenda for trans people. Can you please speak to us a little bit about sort of what you see as the key issues, what's currently on your agenda?
Yeah, I mean, obviously, as I mentioned earlier, right, like the work that we do is very intentional, and obviously the work that we do is informed by our community. And also, we try to be strategic in the work that we do, right? And for us, it was important for us to develop a policy agenda that will support us into making sure that that we support our community to get a better place within our society, right? And the policy agenda focus on, for us to focus on 5 specific things, right? Which is housing, employment, economic development, reentry services, data collection, and health, right? And so this is, for us, is sort of like a road or a roadmap, if you will, for us to do the work that we need to do. And and as a result, I am so happy to report that we learned that for the first time in the history of the state of California, a bill was crafted, introduced, organized, mobilized, and pushed all the way through for the governor to sign Assembly Bill 2218, which is the Transgender Wellness and Equity Fund, which for the first time in the history of California, there will be a fund that will be dedicated into support and build a healthy trans community across the state of California. And so, and I also want to talk about, the report that we also did, which is people can have access to it at our website, which is the transforming the workplace, right? In which we wanted to make sure that we learn exactly from people here in Los Angeles to see what are the things that needed to be done in order for people to be able to get employment, right? And one of the things, some of the things that we discover is that even people who are trans, who are employed, right, are continuously harassed, right, both by customers, by employers, supervisors, and predominantly, they don't get promoted if they don't do sex favors, if you will, right, to some of the supervisors. So, there's so many challenges that we definitely need to, tackle and really talk about that people don't necessarily know about, right? And so for us, developing the policy agenda is just one way for us to ensure that, in some ways we influence, again, at the macro level, and really transform the way trans people are situated within our society. And, and also, right, like when we did the policy agenda, that was like almost 2 years ago, right? And that was obviously pre-COVID, right? And so I think it's important for us to understand where trans people was situated in 2020 pre-COVID, and how, because of COVID-19, trans people it's going to be even set further behind than how we were in all areas, right? I mean, those who did have the privilege to have employment, right? The majority of those individuals lost their employment, and we know how hard it is for us to get employment, right? And so, for the first time last year, Los Angeles County, when they did their homeless count, they counted about 1,000 transgender and non-conforming people living homeless on the streets, and we know that because of the repercussions of COVID-19, there are going to be more trans homeless people here in Los Angeles, and so we have to think about those things, right? And how we are going to be able to support trans people through this pandemic and beyond.
Thank you, Bambi. David, I'd like to turn back to you briefly. Just one more question on this topic. We've already touched on a number of different sort of key cases, both at the federal and state level, relevant to the trans community. But are there any other Supreme Court or other major decisions that you think of that really highlight important issues to the transgender community?
In cases that are coming sort of down the pike?
Mm-hmm. Or recent decisions.
Sure. I mean, I think the two that Shannon just alluded to, applying the Bostock rationale to Title IX, are certainly critical because they clarify that when Title VII, which says employment discrimination on the basis of sex includes transgender status and sexual orientation, that thinking, right, applies to every federal statute that prohibits discrimination because of sex. And so, anybody who wants to make an argument that somehow, well, that's unique to Title VII, it doesn't apply to education, it doesn't apply to federal contracting, doesn't apply to healthcare, whatever the case may be, that person is wrong, right? So I think we'll see a few more of these cases kind of coming through the courts. But I think, as Shannon alluded to, right, we expect them to be resolved in a fairly quick way. And those two cases, Casper and Grimm, I think laid the groundwork for those decisions. One case that we're looking at closely coming up in the next term is the Fulton case, which raises the question of whether Philadelphia's law that prohibits discrimination on the basis of sexual orientation and gender identity can be applied in city contracting, can be applied to a contractor for the city does foster care placements and is run by the Catholic Church, and whether they can say that because their religion, I guess, teaches them that they wouldn't want to comply with this law, whether they can, under the First Amendment, seek an exemption from sort of a law that is otherwise generally applicable. And that's a case, of course, that we're watching closely because, religion is kind of often a thing that people point to when they are seeking to justify discrimination against trans folks or LGBT people generally. And that's kind of an American tradition of that, right? I mean, it used to be the tradition of the thing that people would point to in justifying race discrimination. And the Loving v. Virginia case, which overturned Virginia's same-sex marriage ban in the 1960s, is sort of famous for this quote that the judge who sentenced the Lovings for the crime of being married to one another said in his sentencing, he said, God created the great races of the world different and placed them on different continents, and but for man's interference in God's plan, we wouldn't need such a law. So people can sort of dress up discrimination in religious language, and so the Fulton case is kind of the latest case to look at that, and so we're obviously keeping a very close eye on that one as well. It could definitely sort of change the way that discrimination law protects not just LGBTQ people, but potentially anybody, right, who could face discrimination by a person pointing to some kind of religious or seemingly religious motivation.
Great, thanks, David. And you've set us up perfectly for kind of the next topic we wanted to talk about, because we've seen the Supreme Court kind of grapple with these issues of religious expression, and certainly it's been in the news, and we'll talk about the nomination of Judge Amy Coney Barrett and what that could bring. But certainly that has brought forth the religious expression questions and kind of what the Supreme Court has done. So Shannon, I kind of wanted to turn it to you and talking about what questions the Supreme Court has left unanswered about how protections for religious beliefs and expression interact with its expansion of Title VII's protections.
Yeah, well, it's left all of them unanswered because it had to, because this is the first time the Supreme Court has held that Title VII protects LGBT workers. So they haven't had any opportunity yet to decide a case that poses a conflict between those protections for LGBTQ people in the workplace and possible defenses or counter assertions of religious liberty or some religious exemption. So the court did note that in the decision. There was a paragraph where they're like, hey, just for the record here, we're not deciding in this case anything about how this holding may affect people who are employers who are raising religious liberty defense claims in the future. That said, this won't be a new thing. Like Title VII, employers under Title VII do have some religious exemptions. So the court's going to apply the same legal framework to LGBT claims as it will to other sex discrimination claims. And under Title VII, there's limited protection for religious employers. An employer under Title VII can't invoke religion as a justification for discriminating based on sex or any other basis. But there is a provision in there that allows employers to favor people of their own religious employers to favor people of their own religion. And so that there may be cases that come up where an LGBT person brings a Title VII claim against a religious employer, and the employer's defense may be, no, we're not discriminating against you because you're gay or transgender or lesbian or bisexual. We're discriminating against you because we don't think you're a bona fide member of our faith. You're not following the tenets of our faith. That kind of argument, that we don't think a person of our faith can be, for example, married to a same-sex spouse, or we don't think a person of our faith can undergo a gender transition. And the courts were going to have to grapple with those issues. And, I imagine we will see some cases like that. There is another possible religious defense to a Title VII claim, and that would be based on the Religious Freedom Restoration Act. In the past, I wouldn't have thought that would possibly be a defense, because historically the court has not allowed people to invoke RFRA to justify violating an anti-discrimination statute. That's a pretty new and bold and disturbing and concerning development, but the court has come in a case called Hobby Lobby, where they did allow an employer, and a for-profit employer at that, to invoke the Religious Freedom Restoration Act to justify violating a law that requires employers to make contraception available to women, which is, I think, a kind of anti-discrimination protection and equality protection. But I will say the court in that case did say that one key part of its holding was that no one was hurt, because in that case, even an employer who invoked the Religious Freedom Restoration Act to violate a federal law that requires employers to make contraception available to all employees, that even if the employer was allowed to do that, the female employees would be able to obtain contraception by a different route supposedly without any added burden to them. So the court was really clear that if anybody had been harmed by the invocation of RFRA, that the outcome might have been different. So I hope and believe, and have to believe, that the Supreme Court is not suddenly going to say that it's fine for an employer to violate an anti-discrimination law causing serious harm to someone, like firing an employee, for example, and be justified in doing that just by saying, well, this burdens my religious beliefs, and so I have a valid defense under the Religious Freedom Restoration Act. So these are going to be active areas of law, and something that we're all going to need to keep a close eye on. But I'm pretty optimistic the court's not going to do anything too drastic or that would mark too much of a departure from what they've done in the past.
Thank you, Shannon. And building off of that, the Bostock ruling, seems to also have important implications for other areas of law as well. Not just religious rights. For example, one of the Trump administration's first actions after taking office was to rescind Obama administration guidance that interpreted Title IX to prohibit discrimination against transgender students. And on this issue, Adam, I was wondering if you could sort of speak to us generally about the impact of the Bostock ruling on Title IX.
Sure. Actually, Shannon and David described this a little bit earlier, but basically the approach is there's different sex discrimination prohibitions in different settings in the 1964 Civil Rights Act or other statutes, including Title IX, which covers educational settings, and courts before and after Bostock have interpreted Title IX to prohibit gender identity discrimination as a form of sex discrimination. As you noted, the Department of Education towards the end of the Obama administration issued guidance interpreting Title IX to cover gender identity discrimination and gender expression. The Trump administration rolled that guidance back early on in the administration, and now those issues after Bostock, I think, have sort of accelerated consideration of these issues. And I'd maybe ask Shannon to weigh in on the current status of what's happening with the Department of Ed.
Yeah, it's not good. The Department of Education under this administration has taken a just surprisingly hostile view towards the just basic equality rights for transgender students. And so they have, as has been noted, they've taken the position that Title IX doesn't protect them at all. I think that's now clearly been contradicted by the U.S. Supreme Court in the Bostock decision. But the Department of Ed does not, they don't seem to be paying attention to that decision. They ought to be following it, but they're not. So instead, they're continuing to press forward very aggressively, claiming that transgender students do not only do they not have protections under Title IX, but they're actually taking the position that when schools protect transgender students in sports, when schools allow transgender students, transgender girls to play on girls' team and transgender boys to play on boys' team, that violates Title IX. It's really quite a shocking, extraordinary, extreme position for them to take. I will say I think we were all worried that this has come up in a specific school case in Connecticut, and I think those of us who work in they were going to be really aggressive and try to take funding away from the school district that's being inclusive, but they've backed away from that, which is very good, and are now taking the position that as long as the schools agree to abide by any ultimate court decision resolving this issue, then they're going to not be trying to deny their federal funding. So all this is pretty concerning in terms of where the level of this administration's negative focus on transgender people and transgender kids in particular. But the good news is that the surrounding law, aside from what the administration is up to, the courts and public opinion and most school districts in this country are, supportive, inclusive, and moving in the right direction.
I mean, that is no surprise, right? Because who is the Secretary of Education, right? I mean, it's no surprise that all of this type of things are happening. I think the question for me and for all of us is like, what are we going to do about to making sure that trans lives are supported in the way they need to be supported, right? I think that oftentimes we just, we just say things and we just, articulate things, or, we make statements oftentimes, but, we do very little to make sure that, that there's, that we fight back. I think there's, particularly with, larger organizations that have a particular, they have some power, let me just say that, right? Oftentimes they don't enact their power on a way that really could create changes to benefit trans people. So I think I'm going to say it's a call to action, but also, something for people really to think about and be intentional if they are, if they mean that they actually care for trans lives.
Yeah, I know we got to move on, but I just want to jump in really quickly. Bammy, I could not agree more with that. One thing that's happening at the federal level, there's an LGBTQ anti-poverty network that has, for the first time, I think, put forward a proposed agenda for the next president, whoever that may be, highlighting the critical importance of insecurity, homelessness, housing insecurity, economic just devastation for the LGBT community, like framing that very squarely as an LGBTQ issue. And then I think another really critical and important development, and that I'm seeing for the first time, is some of the large national LGBT groups really getting behind the transgender woman-led effort to decriminalize sex work, particularly around the recent DC effort, and to really support that and recognize that that is really devastating the lives of so many. The criminalization is devastating the lives of so many people in the trans community. But I would never, none of these flickers of hopefulness, and we've got a long way to go, would be happening without, the work that you and other trans women of color have done for decades now, pushing the movement to take these issues more seriously and put some action where our rhetoric is.
Yeah, and I mean, I can definitely agree. I cannot agree more with you, Shannon, and I appreciate that. And obviously, I appreciate the work that many individuals are doing. But I think one of the things that I believe we're lacking collectively is the actual implementation, right? Because we often develop recommendations, we often develop policies, you know what I mean? But a lot of times these documents are just put on a shelf, right? And so if there's not an actual implementation plan, and that also happens with legislation, right? If there's not an implementation plan on how this is actually going to take effect, then it's not going to work, right? And we're very lucky that we live in the state of California that has the most trans inclusive legislation in any other state, right? But again, there's laws that protect trans people. Many trans people don't even know about those. Many people don't even know about, those legislation, and that's why they continue to portray discrimination against our community. And so, it's great to develop recommendations and do all of those things, but I think we need to really be intentional about what needs to happen in order to change the landscape and the livelihood of trans people in this country, particularly now, as I mentioned, that our community, we have experienced a global pandemic, right? But also understanding how trans people are going to be set even further behind than how we were before COVID-19 hit.
And I just want to kind of echo those thoughts. I think they're so important, and just kind of make 2 points, which I just think kind of build on it. First, I think our movement for a long time has had this fetishization of like coloring maps when we have a positive new law passed in a certain state, and we look at our state issue maps and think, oh, we're flipping all these laws in the country, and all of that needed to be done. We needed to get rid of sodomy laws. We needed to pass non-discrimination protections. We needed to protect families of LGBTQ people. But when you're talking about criminalization, when you're talking about poverty, that is not as simple, I think, as Shannon and Bambi are saying, is passing a single law. They are complicated issues that are going to take a lot of different types of responses over a longer period of time. And so I think it's interesting that kind of these centers of advocacy are happening outside of the larger organizations around poverty or criminalization. And that is where in Bambi's group, that's where some of these policy agendas are being set. And the Williams Institute released a report this week that showed most LGBT people who are poor were born in poverty. So if you want to address poverty in the LGBT community, you have to address poverty. I mean, you have to address the reasons why everyone is poor, because going back to intersectionality, it's the way that all these parts of our identity work together. And I'm going to be a bit of a glass half empty guy with the decision, because it's a great result. Good reasoning, I think, not just for LGBTQ people, but more broadly. This is a good reasoning for some of the reasons I explained more broadly for the civil rights statute. It's not the type of opinions that Justice Kennedy was writing. So I officiated at weddings and read parts of Windsor and Obergefell. I will not be reading parts of Bostock, nor will anyone at anyone's wedding, because the humanity of who we are is taken out. And I know we're going to switch the nominee, but I think it points to some of the fragility of this case and the work that we need to do with these justices and more largely in society. And I think you can break it down pretty simply as Justice Gorsuch doesn't really understand gender identity or transgender people. Justice Alito thinks they're a problem, and Justice Kavanaugh doesn't even know that they exist yet. So Gorsuch, I think almost every time he uses the word transgender, it's homosexuality, another term he's using deliberately, and transgender status. And when he gives examples, they're almost always dealing with gays and lesbians. So transgender people and bisexual people are kind of in there. Bisexual people are left out. Transgender people are kind of either as an appendage or rarely mentioned. When he tries to get into an example, he kind of bungles the language. So good result, well-meaning education on what's actually going on. Justice Alito, and I think Shannon went through this, it's just every problem he names that's going to have to be resolved focuses in on transgender people. He even creates a category called constitutional issues, but apparently the one issue in that category is trans people in the military. And then Justice Kavanaugh, I think, as a kind of bone to the LGBT community, writes at the very end of his opinion how much work gays and lesbians, again, not transgender and bisexual people, have done to get to this moment for the Supreme Court decision. Never mentions the word transgender in his entire opinion. So I think as we switch to the new nominee, we have to remember kind of what this case did and kind of the work it indicates that we have to do with these justices.
And I want to jump in and kind of ask a question, because Brad, you make a great point that certainly I think we'd say in this case and in this decision, you know, a great clear result for what we were hoping for, and so a clear result there. But court watchers and pundits and speaking, kind of looking at the decision, right? Some people have said, "Gosh, this is the death of affirmative action potentially," or the language can be used to potentially become the death knell of affirmative action if we're looking at individual status and what that means, and we're not looking at a group as a whole. And the language from Gorsuch where he writes, it's irrelevant what an employer might call its discriminatory practice, how others might label it, or what else might motivate it. And certainly folks saying that's really where Gorsuch and Roberts were potentially going, or going long-term, or how this decision could be used long-term. And I just wanted to throw it out there if, you know, folks are thinking about that, have thoughts on that point, because certainly in this case we would say great, clear result. And I, for one, was very pleased, of course, when the result came out 6-3 versus a 5-4 decision. But any thoughts anyone has on that point and how the ripple effect could be as to other potentially, we would think, advantageous policies and how this could be used along those lines in the future?
I'll just jump in real quick. I know there's been concerns expressed that the decision could use to further undermine affirmative action, which the court has already severely undermined affirmative action. But I'll just put in a plug. I think it's important that we who support affirmative action not jump to that conclusion or do their work for them. There's also very strong arguments that it does not do that. And we need to, in my opinion, we're better served by putting those forward. There's really prominent legal scholars, Carrie Franklin, Katie Iyer, who already have articles in the works advancing the opposite view, that actually properly understood and read and applied these decisions should support affirmative action and should support a more expansive understanding of race discrimination as well as sex discrimination law. And I think, we've seen that this court is, even the most conservative justices on this court, including Justice Gorsuch and Chief Justice Roberts, are not, they're human beings and they pay attention and listen to the discourse around them. And it's just, we need to do our job, which is put forward the strongest possible arguments we can about how and why the decision can and should be applied in positive ways. So just to say that, I think that, I am cautiously optimistic about the future if we do our part.
Mm-hmm. And before we move to our last topic, I did just want to turn to you, David and Bambi, on the issue of the Affordable Care Act. So this is another area of law where we sort of expect to see some impact from the Bostock ruling, given the Affordable Care Act's prohibition of discrimination on the basis of sex as well. And I know David and Bambi both involved in some ACA-related litigation. Could you speak to us a little bit about that, please?
I should go first. Bambi, do you want to start or should I?
Please do. I'll follow your lead.
Okay. So yes. So the Affordable Care Act contains a provision that prohibits discrimination on the basis of sex in the provision of healthcare. And that has been used quite successfully, actually, by a number of transgender advocates to achieve successes in ending exclusions for transgender healthcare from health plans around the country, and also to ensure that healthcare providers, especially ones that are sort of run by the public sector, cease to discriminate against LGBT people because they are LGBT, and to bring regulations, especially again at the state level, of health insurers and healthcare providers into line with the ACA, right? So, to ensure that licensing, regulation, and so on of healthcare professionals, of healthcare facilities, and health insurers includes ensuring that discrimination on the basis of sexual orientation against patients is unlawful, that health plans, again, can't exclude gender-affirming care, that the condition we call transgender broken arm can no longer exist, right? Which is to say, you walk into a hospital and you say, I have a broken arm, and the doctor says, well, I don't really know how to treat trans people. It makes me uncomfortable, or I'm not trained in it, right? And so they don't treat you. That's an all too common thing, despite the flippant name, and that's illegal under the ACA. So there's been a lot of really positive change as a result of that law. Furthermore, in 2016, the Obama administration, issued a regulation, affirming that sex in the statute includes gender identity. Now, interestingly, I think like maybe 2 days after the Bostock decision said because of sex includes transgender status and sexual orientation, the Trump administration then sort of tried to repeal much of the Obama era regulation clarifying that the ACA without a doubt does apply. And that the timing of that was like bizarre, inexplicable, whatever adjective you want to use, right? I assume they thought, like many people, that perhaps Bostock was going to come out the other way, and this was going to be kind of the start of their victory lap. That didn't happen. So now we have this regulation, right, that says, well, sex, because of sex in the ACA, does not necessarily include transgender status and sexual orientation. And then the Supreme Court saying because of sex does include those things. So their sort of bald-faced violation of Supreme Court precedent that was like 48 hours old is resulted kind of immediately in, I want to say 5, maybe 6, I'm not quite sure of the number of lawsuits challenging that rulemaking. And so the rulemakings messing with the definition of sex has already been preliminarily enjoined by one of those in one of those lawsuits. So it sort of never took effect, or maybe did for like a day. And so we continue to think that the correct interpretation, right, of the ACA is that it does continue to prohibit discrimination on those bases. And I think all of this litigation that's unfolding is kind of continuing to affirm that. But I know since Bambi is actually the organization that Bambi runs is a plaintiff in one of those lawsuits, I thought it would be really interesting if you could talk a little bit more about that one.
Yeah, thank you, David, so much for providing this context. Yeah, and as I mentioned earlier, right, the very reason why we exist as an organization is really for us to fight the systems that continue to keep us in the margins, right, and that continue to oppress us and discriminate against us. And the reason why I do the work that I do also, it's because I am a privileged trans Latina mujer inmigrante, right? And I have experience in the past, health care discrimination, right? But through our membership at the national level, many members also, tell us their experiences And that's why when we were approached to be part of this cohort of organizations and individuals, there, for us was obviously a no-brainer, right? Because we are representatives of our people. And, I also want to say that, we as an organization, and I personally, I'm very glad that we're part of this group of individuals who decided to take a stand and really push back against the current administration. And I'm going to say, this sort of like it's a way to show the intentionality that, the I guess the unified work that needs to happen, right? Because oftentimes, again, Brad, talked a little bit about this, right? That the T is oftentimes, within the acronym, right? It's silent, right? And it's oftentimes also very used very loosely, right? We talk about LGBTQ, but the issues, the needs of people who are trans or gender nonconforming are not specifically highlighted. And for us to be part of this claim, obviously, it's definitely a sign of that, right? That there has been intention into really broadening the spectrum, right? The acronym of the spectrum, right? And so, this obviously is something that continues to affect our community. And, the rule, 1557, right? Like it's one of those things that, should protect us. And we're definitely fighting back for that.
And I should also add, too, like this is totally, as Bambi is saying, like a live issue right now in real time. And we at TILDEF are litigating another one of these lawsuits. But ensuring trans health protections is like something that we are really centering in our work. And so if any of the folks who are watching this panel, have questions about like what is changing in the law right now, or if they have experienced discrimination, or if they're wondering like what can their company do to make sure that they're not even inadvertently discriminating, like they can come to TILDEF and we would happily answer those questions.
And I also just want to add a little bit to that, again, for those folks who are watching this panel, we have to do more, right? I know that Out and Equal really focuses on, employment, and members of this, members of Out and Equal, right? Like are often companies like 500 Fortune companies, right? And so, just having a policy is not going to employ people, right? We need to find ways to truly invest in trans lives and fund programs that create paths to employment, like a pipeline for trans people to be employed. And I would appreciate if you can share the link that I put in the chat for people to to have access to a report that we did specifically here in Los Angeles, which is called Transforming the Workplace. And it's an opportunity. In 2020, there is no excuse for people not to actually do something about it, right? Like just saying that I support you is not enough. There has to be an intention and there has to be an investment in trans lives.
Appreciate it. Thank you, Bambi and David. And along those lines, kind of staying focused on the court or turning our focus back to the court for kind of our last few minutes of this panel, right? I think what's clear is, yes, Bostock, good result with respect to the legal result, and certainly the legal result we hoped for, but we have a long way to go, And certainly many more fights we're going to have, and whether that's in the legislature or certainly in the courts, that certain questions are going to come before the courts in the future and are coming before the courts in the future in the Supreme Court. And so as we turn to and look to the unfortunate passing of Justice Ginsburg recently, right, kind of what do we see going forward? And I'll kind of open the floor to anyone who wants to share kind of in our last few minutes kind of what they see, what they're expecting from the court as some of these unanswered questions we've talked about may come before the court, and what we're reading in the tea leaves and what we're thinking looking forward as to the Roberts Court with a new member, whether that member becomes Judge Barrett or whether that member is someone else, depending on what happens in November and what kind of happens at the U.S. Senate. So any thoughts there that anyone would like to share? Don't be shy.
Yeah, I'll jump in, and I just sound the same theme that I think that I think we do really need to we do really need to understand. And the nominee, I think, submitted 65 pages of responses to questions today in preparation for her hearing, and she was asked to pick out the most significant cases that she's decided this far. And if you read through the cases, they're anti-labor. They're anti-immigrant. They're anti-protections against sexual harassment. There's no LGBTQ case in that list. But I think on everything that everyone has been saying on those panels, those are LGBTQ issues. And so if we're going to undermine the rights of employees, if we're going to give virtually no rights to people in the gig economy, if the Supreme Court is going to be even worse on immigration issues or uphold, God forbid, the policies of this Trump administration or one in the future, these are all LGBTQ issues, and we need to show up for them, just like people working on immigration issues and people in the labor movement and people working on anti-racism showed up for us in the marriage equality cases and in anything that you name. And so it doesn't look promising for LGBT rights, but our concerns kind of have to be bigger than that at this moment.
Certainly, David, did you want to add something?
Yeah, I'll just add one other thing. Well, maybe two, because I'm a lawyer. I can never stop at one. So obviously the nomination of Justice Barrett is of concern, not only for the reasons just articulated, but also specifically for the transgender community, right? I mean, she has indulged in the stereotypes of trans people as sexually violent or dangerous to children, and that is simply not acceptable for a federal judge, and so that alone I think raises questions about her service, fitness for service, excuse me. And we also know that she has associated with, I guess, been paid as a speaker of Alliance Defending Freedom, which is a group that has been named a hate group by the Southern Poverty Law Center. There's a saying in Spanish, "Decime con quién andas y te diré quién sos," like tell me who you hang around with and I'll tell you who you are, right? And so a sort of again both her sort of professed willingness to demean trans lives and her willingness to associate and with and be paid by groups that target trans folks is deeply concerning, for sure. But the second thing I wanted to say is that we did again win this historic victory this year. Changing one seat on the Supreme Court doesn't make that go away, and so we are still sort of, I guess, emotionally like in the afterglow of that. Like we still feel like winners, and whatever happens with the nomination of Judge Barrett doesn't change the fact that we are winners, both I think morally and legally. So it's an exciting time, I think, to be working in the courts, despite whatever the particular short-term outlook is.
I'm happy leaving this panel with feeling like winners, or at least with some optimism. I think we could all have some optimism at this point. So we're just coming up to the end of our time. So certainly appreciate everyone's time. Thank you all for taking the time to speak with us, to share your views. On behalf of Elizabeth and I, we very much appreciate your time, and certainly thank you to everyone who joined this panel and watched this panel. And if you have any questions or follow-up, of course, feel free to reach out to any of us. Again, thank you for participating, and thanks to Out and Equal for having this forum where we could all get together and share our views. Thank you.
Thank you.
Thank you all.
Thanks, everybody.